Thank you, Mr. John Gomez, and all the distinguished members of the panel, and my dear friends. It's truly a very significant honor to me in having been invited to be with such an august learned gathering to speak on such complex topic as arbitration. I very much wanted to be here in the morning itself and listen to all the discussions and deliberations that have taken place, so that I thought I could learn more about the nuances of the whole arbitration law procedures and all that. But unfortunately, something turned up and I couldn't be with you in the morning session, but I'm happy that I'm here with you for the afternoon session. It's, as I said, it's a significant honor that I'm not one from the very learned profession of law, but a very supportive younger sister profession of chartered accountants. But we do handle a lot of arbitration matters. In my firm, we have close to 1,000 commercial clients in our offices altogether, and many often you see all kinds of commercial disputes come up, and we are completely, in the dark in approaching them and in suggesting proper solutions. But let me tell you, arbitration is the last resort that we suggest to most of our clients, for the simple reason that it is so complex, and more than anything else, it takes a lot of time. Either you go for litigation or you go for mediation is what we normally advise, because arbitration also is very much, as was explained, it takes you to long-winding litigation. Ultimately, if some other parties want it, it will be challenged. So why not? Why save time? Go straight for litigation. But the mediations are often, in 60, 70, 80% cases, the mediation is very effective. And we do undertake that responsibility substantially ourselves in trying to bring both the parties together and understand what are their problems, the genesis of the problem, and what gave rise to this problem, and what went wrong, and what could be the possible loss, commercial loss. We use our financial accounting knowledge and try to estimate the loss this way and all that, and then do some sort of an intermediary or a semblance of an arbitration work in the mediation process also, and bring them together, several discussions. And we take the opinion of lawyers also for these mediations in a very informal way. I have had the privilege to work with Barrister Kurian with Menon and Pai for more than 3 decades. And hundreds of cases of commercial mediations, we have together handled and settled them also. Because the process is by and large very simple, and both parties will accept, and there will be no litigation after that. But the arbitration process, yes, it requires to be standardized and stabilized. It's a long drawn process, and you need to address, you see how we thought when the Arbitration Conciliation Act came in 1996, we thought it will bring a lot of cohesion to the whole process, and it will help substantially to settle matters. But it has not solved the issues to the extent that one would have. An arbitration, as you know, certainly to be successful, it has to be very simple. The whole process has to be simple. It should be understood by the layman. It should not have too much of complications in that. It should be involving the parties who are involved in the litigation or the arbitration. They must have a very direct role at every stage as the arbitration proceedings go through, to advise their counsel as to what should be done and what should not be done. And there should be certainly checks and counter-checks to see that this do not get prolonged unduly. And the solutions, the pre-trial stage has to be as short as possible and as simple as possible. And all the documentation verifications also should be done at the shortest possible time, so that you get the decision in a fair manner at the quickest possible time. The trial stage also should not involve long winding process, adjournments, and each advocates asking for more time and further filing documents and further documents, and the arbitrators wanting more and more time to study. And in some cases, the arbitrators themselves being changed. The parties change the arbitrators withdraw, and new arbitrators come. The whole procedures having to be gone through all over again. And it takes, normally for large cases, it takes substantially long time. And the award, the much awaited award comes. And it used to be, old days awards used to be very simple, very short and all that, like our former Chief Justice M.S. Menon's judgments. Those days it used to be, we all used to love that, especially when he sits in the tax bench and all that. Very rarely, though, the judgments used to, used to have its own character of simplicity. and all the substance, built into that, no doubt. But these days, the arbitrators go on writing, and they justify all that, and then it gives somewhere or the other, it gives, a case for judicial interpretation, as the learned judge said. Howsoever you may not want to go for judicial interference and all that. Certainly, when the matter, no board can take their own decision. I sit in several boards of corporates, small and big and large, and it is impossible for any board to take a straightaway decision, okay, let us accept this award and be done with that. The first time when it is reported to the board, we say that refer to the legal opinion. So the award goes straight to the legal opinion, and the lawyer will say yes, here and there. But finally, he will say it is better that you challenge this. You may have a case, you challenge that. So even if you have got 1%, 5% case to challenge an award, no board of directors in their responsibility would ever decide, okay, let us not challenge this and close the matter and all that. Especially when in government corporations, we often find in government companies, it is absolutely impossible for the board to accept any award for that matter. There will be some loophole, and the matter goes to the court, and when the judicial interference takes place, you know what it happens. I have been an arbitrator myself in several cases. I have stopped it for some time now for the simple reason that when we agree to be an arbitrator for large companies involving commercial disputes, national or international disputes, prima facie we will think that cases are not that very complex. We will be able to bring the parties somewhere together. We should be able to see that the matter is closed. After all, there are not many vexatious issues, so why not? Then we start with that. We discuss before the, I sit as arbitrators on behalf of the chambers of commerce very often where our members' interests are involved. So between the arbitrators, we discuss very often that yes, we should be able to form an idea. It should be possible for us, let us say, to close the matter in 3, 4, 5 months in any case at the worst, and then we start, with an open mind. But the moment the lawyer enters and starts, presenting the case, it takes an entirely different dimension. It goes off completely out of control of everyone. Sometimes become big cases, very big cases. Let me tell you a small example. I was an arbitrator in a case where one of the biggest air conditioning company was involved, and the other party was one of the freezing, the seafood exporters who had a freezer equipment. And the air conditioning equipment, freezing equipment supplied failed, and it entailed in some losses for the seafood exporter. I will be very brief for time constraints. And they estimate the loss to be, we all discussed it, that they estimate the loss to be nearly 4-5 lakhs of rupees. The seafood exporter has suffered a loss because of the non-performance according to the rated capacity or standards of performance level of the equipment. And the case was filed against the arbitration, went to the arbitrator, both arbitrators talked together. And they were willing somewhere, initial discussions. But then one side suddenly brought a brilliant lawyer, and, he completely turned around, and he made it a case against the fishing company, the seafood export company. They said, you did not keep your surroundings well, your walls and various things well. You caused the loss and all that, and because of your non-maintenance of the freezing area properly, so many reasons this loss was entailed. And he said that it meant loss of reputation to us also, so you need to pay us 10 lakhs. So then the other fellow jacked up his against 15 lakhs. Finally, what could have been 5 lakhs went up to 70, 80 lakhs, nearly 1 crore of rupees years ago. So then we arbitrators, both of us sat together, we called them, we cannot go on like this, it will go on and on and on. So somewhere, finally, we agreed both the parties to withdraw the whole matter and settled, as you say, off the court. So this happens, the lawyers are right, certainly the lawyers are right. If you look into all the aspects of the law, they have to do the justice to their clients. So this procedure takes a long time. The question is how to evolve a proper ecosystem for expeditious, judicious, disposal of all the arbitration matters. International arbitrations are far too simpler, no doubt. I had occasions to handle the arbitrations on behalf of my clients, not appearing before them, on advising them on commercial side, councils before Singapore and in UK and Hague and all that. They are a little more simpler. I think at all stages in the pre-trial stage, at the trial stage and award stage, it goes through. The arbitrators are very powerful, and they don't, allow any kind of trial. They set the targets well in advance. They say, okay, before the pre-trial stages, they study the whole matter that you are given such and such a time, file all the documents you want. You have to file it before we sit in the first hearing itself. You file all the documents you want, whatever you want, we'll give you time. how much time you want, you decide. So 10 days, 15 days, all the documents have to be filed before a given date. And the arbitrators study this document so very well and come and the hearing goes on 1 or 2 months and all that. And that stage, around the stage when the documents are well studied and all that, they ask us, now we have to set a time limit. How much time shall we close this? You tell us. We can't go beyond that. So let both the parties agree for the time limit and all that. The time limit is agreed maybe 2 months, 3 months, 4 months. No, we have no time. Then they will say, tomorrow is that. Lawyers will say sometimes, no, the other reason, this reason, that's whatever the reasons, you set a time. And the time limit is set. When the time limit is set for completion of the trial and the award and all that, you know what the cost is going to be. And the procedure really takes off very fine. You don't get a feeling, sometimes we feel as they are pushing through, because that is all an arbitration. After arbitration, you can't go through all the matters, you can't be 100% right. In any arbitration award, you say that they are nowhere, you can say that the arbitration award is 100% right, or even sometimes, maybe totally wrong also. Yes, when judicial intervention takes place, they have simply thrown away many awards. Even awards which have been passed by learned Supreme Court judges, courts have rejected them as the fundamentals have not been looked into. As he correctly said, public policy comes into effect and all that. So therefore, but there, okay, it already gives a semblance of everything being heard and the award is also passed. And by and large, the international arbitration awards are accepted, right or wrong, whatever may be the cost. But at times they are taken to, I had one very interesting case, very difficult case. One of the large corporates here had a very major case against a Japanese company. And it went on for quite substantial time, and finally international arbitration was agreed upon. And they say the seat was agreed to be at Singapore, and very learned arbitrators came from UK and all that, and the arbitration award was finally, settled. But when it was all fair, in all respects we would consider it would have been fair, the Indian party was affected, badly affected. So he challenged it. Indian party challenged it in the Indian courts, For long it took whether the admissibility of that award itself, the jurisdiction and of the Indian courts were all subject to challenge. But finally it was admitted and it went up to the Supreme Court, nearly 15, 16 years. The case has not yet been disposed of for different reasons. So this what is happens, rightly or wrongly. So we need to have a very expeditious mechanism for that. First of all, I would say that, in the drafting of the agreement itself, in many agreements, who drafts, we don't know. The arbitration clause, is not properly drafted. The whole mechanism is not well defined. The process is not defined. So it has to start from that point itself. And what are the cases which are fit for arbitration? In UK or Singapore, you have a machinery for that. We don't have to that extent that kind of a sound machinery. The arbitrators will sit, the institutional mechanism, the importance comes into that. Where we want an institutional mechanism is before it goes into the arbitration matter, the institution should interfere and say whether it is an arbitrable case or not. If it is not, if they say many of no, there is no case for arbitration, it is accepted and closed. Now we need that kind of a mechanism. And if arbitration process is on, there has got to be a time limit, there has got to be a cost element in that, there has got to be a process involved in that. The whole mechanism, requires to be completely redefined and redone. So I would feel that, with all these laws being what it is, several amendments have been made to the Arbitration and Conciliation Act of 1996, but yet we have not reached a stage where parties get the kind of satisfaction which, one has to derive out of arbitration. So I think we need to discuss about that. I'm happy that Justice Sri Krishna Committee has been appointed. But then these committees also, we had a parliamentary consultation committee, which has done a very good job. But most of the advice or most of the recommendations of the parliamentary consultations committees have not been fully implemented, or we have not understood them to have been so fully implemented. So therefore, at least before Justice Sri Krishna's committee, we need to suggest a possible mechanism, at least as far as international arbitrations are concerned, because India, said and done, the worst thing they talk about any international conference is that you don't have a proper arbitration mechanism. Your arbitrators are not well educated. Your arbitrators are not well prepared. Now, who should be arbitrator? What should be the qualification of the arbitrator? These are all have to be well defined, absolutely well defined. All said and done, howsoever we may not like the judicial officers, retired officers to be arbitrators, they have their own time. You have got to, it's not very easy to go and approach a retired Supreme Court judge and all that. But still, finally, the confidence seems to be, for general, good corporates and all that, the measure of confidence is there when there is a judicial officer. At least he'll be fair. There is a feeling that he'll be fair. He may not be influenced and all that. But who is to appoint that, arbitrator? Is it an administrative function or is it a judicial function? We need to settle that. Of course, in SBP Patel engineering case, the 7-bench constitutional bench has said that it is a judicial power. Earlier, some of us were very happy when the earlier case, it was decided, Rani's case, it was said, Konkan Railway or so, that it was an administrative power. Okay, administrative power to appoint is something, okay, acceptable. But if it is a judicial power, the whole process becomes judicial, the arbitrator himself becomes judicial, and everything becomes legal, then it is absolutely essential that when it handling commercial cases, the arbitrator should have a sound commercial knowledge, basic knowledge of business, basic knowledge of international trade, basic knowledge of various operational activities, knowledge about finance, about profitability, because it's determining the loss on both sides. A good amount of financial accounting knowledge are also required. We can't expect that, sitting in the bench or in the bar, practicing the bar, learned advocates would have had that kind of a knowledge. So perhaps, they require to be then educated. All judicial officers will come with an open mind. If the arbitrators also come with an open mind, he has to be educated by the lawyers. Then the lawyers themselves should be, very thorough with such matters, where there are, very complex business issues are involved. We find that especially when it comes to, international disputes, they make their case so very strong. The poor Indian parties suffer very often. It is because of their expertise in framing it like that. Very solid case, whether it is a patent case or an IPR case or any such case, when an international party is involved, they make their case so foolproof. And we are not, that very competent to drop that case to that extent. So therefore, very often, the international, efforts, the international dispute mechanism do not help the Indian parts. So we need to work on that. What could be the mechanism available? What should be the competence on that? Probably the arbitrators, when it involves, major financial disputes or commercial disputes, it may not be a bad idea to have someone with a financial accounting background, a banker or a chartered accountant or someone like that, also to sit in the arbitration panel, so that it will be much easier. I feel it will be much easier. Because you take another comparable institutions, the Income Tax Appellate Tribunal, with which we are all concerned with. We argue something like 7-8 cases, in a day. Very major cases. It may involve some, say, 1 crore of rupees to sometimes 30, 40, 50, 100 crores of rupees. In my close to 43 years, it's not since 7-8 years, I'm not before the tribunal. In my 40 to 43 years of my tax practice, I would have appeared close to 22,000 tax cases. And all of them disposed fairly in acceptable time. There are also judicial officers are sitting there. Justice Fatima Bibi used to remember in the board. Justice Unishal Krishna Kuruba have appeared before all of them. Justice Ansari. They were all judicial officers who became very eminent judges. I have appeared before them, but they dispose of. How can you dispose 7-8 cases in a day? How can you argue 7-8 cases in a day? So we make it, so comprehensive, so thorough. Paper books are all produced. All the evidences are available. All the evidences which are required for the disposal of a commercial case. So the judicial approach, the legal frame of mind looks into all the questions of law involved. The accountant member looks all the questions of accounting questions or questions of facts involved. And they together, and the judicial member and the accountant member together interpreted the mixed questions of law and facts. And in about 10 days, we get the disposal. And let me tell you, in 75 to 80% of the cases, the tribunal is supposed to be, tax tribunal is the highest fact-finding authority. These decisions are not taken to the High Court for reference on questions of law. We will not allow our clients to go to the High Court unless that the judgment itself is so shady or it is so untenable, which it will not be coming from a judicial member on an accountant member, which used to be sometimes a chief commissioner or a chartered accountant with 15 years plus experience and all that. So if that mechanism could work like that, why should we not an arbitration panel also should have compulsorily for above certain level at least, people who have commercial and business knowledge to help in bringing the commercial disputes. Because we have to get the stigma that nothing works in our country, doing business is very difficult. Only for the reason that there is no proper arbitration mechanism, people are not coming for investment in India. All this mentality, the mindset has to change. I met a good friend, Mr. Dharam Jumani, lawyer from Mumbai. He said the mindset. Yes, that's the mindset. I would close with that. That's the mindset. Our mindset has to change if you have to approach any resolution of any disputes, any controversies, any conflicts. And that is not, which is obtaining in this country, unfortunately, not about businessmen or any professionals in the whole country. If the whole country has to progress, we know for certain there has got to be a qualitative change in mindset. Let us look for those good days to come. Thank you very much.